Thank you. Please be seated. Three cases are submitted this afternoon. They are State of Iowa versus John Penn Kennedy, LSCP LLLP versus Courtney M. K. Decker, and Ghost Players LLC and CH Investors versus State of Iowa. The last case is submitted at this time without argument, and we'll now hear the arguments in the State versus Kennedy case. Counsel may proceed.
May it please the court, counsel. This case presents an opportunity for this court to determine the potential applicability of wing to a police interaction where a defendant is not notified of the offense for arrest, but could potentially be arrested for multiple offenses. Here, the district court correctly denied the defendant's motion to dismiss based on an alleged speedy indictment violation. The defendant was not arrested at the scene, but instead was arrested at the station when booked and cited for public intoxication. Alternatively, if the defendant was arrested at the scene, a reasonable person in the defendant's position would believe he was under arrest for public intoxication and being investigated for OWI. First, the defendant was not arrested in the parking lot. Instead, the defendant was arrested at the station. Now, the state preserved error on this argument by arguing both in the written resistance to the motion to dismiss and orally at the hearing that the arrest occurred at the station and not in the parking lot.
I just heard you say that and your briefs are along the same line as well, that we should apply a reasonable interpretation test to determine what the defendant has been arrested for. Why not just go with what the defendant was booked for?
I think that is that's kind of what the Court of Appeals did in stating that we're applying this reasonable person's test, but what is most determinative is what the defendant is told he is booked for in these circumstances.
Because one can always argue reasonableness in different directions, or usually one can.
Correct.
But if we just go with what the defendant was booked for, there's no ambiguity, right?
Correct. And which is what the court recognized, and the problem that this court was concerned of in Wing, and when a defendant is not told, then there's this ambiguity, but we don't have that here when the defendant is told.
Right, but that's a separate issue. That's a question of when the defendant was arrested. Now, when the defendant is arrested is not really material in this case. The question is, what was the defendant arrested for, right?
Correct. Correct. And looking at what the other circumstances also support that the defendant was arrested for public intoxication and not OWI, beyond what he was told he was booked and cited for at the station. When at the station, he received the implied consent form, which did not have checked that he was under arrest for OWI. It stated that implied consent was invoked because of the failed PBT. And further, while there was questions and there's potential ambiguity at the scene, discussions about drinking and how much he had to drink, this could go to both public intoxication or to OWI, and has been stated any potential ambiguity is resolved when the defendant is told at the station that he is going to be booked and cited for public intoxication.
So are you arguing that Wing does not apply to this case?
Yes, that's the argument, and that Wing potentially might come into play if we had a situation like in Wing, where a defendant is arrested and then let go, and there's no discussion about the arrest, and there's no real conclusion to the interaction. Here, there is that conclusion, and that the defendant is booked and cited for public intoxication and not OWI. So, no, I don't think we need to reach the Wing.
Can you be arrested for one crime and also have a reasonable belief that you have been arrested for another crime?
Yes, Your Honor, and that was a similar issue that this court dealt with in Denison, and that the defendant is arrested at the scene. He's told he's arrested for a different offense than OWI, And the court determined that although he was taken to the station for implied consent procedures, consistent with the rule that this court has applied consistently for decades, that even though they might have probable cause, this doesn't answer the question. A reasonable person in those circumstances would believe he's only under investigation for OWI. And this is consistent with what happened at the scene. The officer, before preparing to transport the defendant to the station, stated, "Well, I'm taking you to the station so we can run some more tests." I'm paraphrasing. "It's cold outside. We need to do more." So based on these facts, a defendant would believe that he was only being investigated for OWI and the investigation was ongoing.
But why does the wing test even apply here?
I don't think we need to reach the issue. I think in briefing the concern was if there was this snapshot question with what all we can analyze when we're making this decision. But I think we don't need to reach the wing issue based on the fact that the defendant was told he was booked and cited for public intoxication. So
The broader issue is, does wing ever apply to a situation such as this?
I
mean,
don't
the wing dealt with a different issue, not
Right,
a speedy trial issue.
I think the problem that we don't have here, but that the court may need to address in the future, is if this court continues to uphold wing when we're determining whether a defendant is arrested, in a situation, for example, like in wing, where a defendant is arrested and let go. This court didn't really address, and it seems to be assumed, what offense the defendant was arrested for. There may be a circumstance in the future where there could be multiple offenses, and there's not a situation where a defendant is ultimately booked or cited for an offense. But I don't think we need to necessarily reach that issue today, because there is the defendant was booked and cited ultimately for an offense, clearing up any potential confusion.
What was his lawyer told that night?
It's not entirely clear from the record. I think it was the attorney was there at the hospital and I believe at the station, but I am not 100% on that the defendant was being booked for public intoxication. And I believe that his trial counsel is also there as this discussion of the urine sample, which would indicate that the investigation is ongoing. So I believe the attorney arrived when the defendant was at the hospital.
And when the police first arrived at the restaurant, the defendant's behind the wheel of his car with the engine running, and they never saw him out in public, so to speak. Is that a problem for charging him with public intox?
No, Your Honor. Well, the police did have information that the defendant had been outside and appeared to be intoxicated, and we might get into the public intoxication. That might be a problem if you were trying to challenge the arrest in some way. The question here is, was speedy indictment triggered on what offense? And the question, that's answered simply by what he was booked and cited for. And thinking of if we needed to apply this reasonable person test, I don't know how the fact that he is found in the car does not change the fact that he is later booked and cited for only public intoxication.
My reading of the record, maybe I'm incorrect in this, is that at the hearing on the motion to dismiss, though, the police officers testified on more than one occasion that, in fact, he was arrested at the restaurant. And so maybe that's where wing has some applicability here, because if you've got the officer there confirming under oath several times that an arrest occurred at the restaurant, not at the station, kind of switches your whole argument, doesn't it?
Well, if we were to apply wing to this reasonable person standard, the court stated it in wing that the subjective intent of the officer and what the officer believes is not relevant to the analysis. What matters is what the officer communicated to the defendant at the scene and what the defendant would believe. That's what the officer is stating, well, as he did at the hearing, well, a reasonable person might believe this. Yes, I agree with that. It's not relevant to the analysis. If the officer had communicated at the scene his belief, that would be a different situation.
Well, I guess I look at it a little bit differently. When you look at the totality of the circumstances here, where they go there, they have this complaint, he has them do the nystagmus test, he has them do field sobriety tests, he's behind the car's running, and all of this flows from there, and then the police officer says, I arrested him at that time, wouldn't a reasonable person perhaps feel that he was being arrested for OWI?
I don't believe so, Your Honor. I think that illustrates a problem with if we do apply or just with the reasonable person test in general. For example, the Court of Appeals discussed, well, he was found behind the car with a car on. Before I went to law school, and probably quite frankly before I started this job, I don't know if I would have known that being in a car with the car would mean I had committed an OWI. And if we're taking this reasonable person standard, I think it's problematic to then determine, well, a reasonable person would know the elements of this offense are met, and so they were likely under arrest for a certain offense.
Let's try this on. He was transported to the police station. In the process of getting into the station, he fell, hurt himself. They take him to the hospital. At the hospital, they read him his Miranda rights. So it sounds like he's under arrest. They invoke implied consent, which applies to operating while intoxicated. And they go through all the testing procedures applicable to an OWI. At that point in time, would it be a reasonable belief for a person in that situation to think that they've been read the Miranda rights, went through implied consent, tests given, that they're under arrest for OWI?
No, Your Honor. It would indicate that the investigation, for OW was...
Well, he's been given his Miranda rights. It sounds like you're under arrest for something, right?
Correct, but it would not answer the reading of Miranda would not answer the question of what is happening and what he's being arrested for.
But after he was given Miranda, he goes through the testing procedures that apply to driving while intoxicated. So what would a reasonable person think at that point?
At that point, if we're only looking at that factors, which I think is problematic and inconsistent with the totality of the circumstances test, the only indication is that he's being investigated for OWI, but I don't think we should, and under the rules that we have that this court has laid out, just be limited to that kind of snapshot. It's necessary to evaluate the entire interaction and the totality of the entire interaction to determine what a defendant would or would not believe if we're applying the wing.
Doesn't that answer, I mean, doesn't that sort of point up the problems with a reasonable person test? Why not just have a bright line rule that you're arrested, if you're arrested and then soon thereafter you're booked, you just go by what they're booked for? Because couldn't one imagine a hypothetical, for example, where the police arrest someone, he says, what am I arrested for? And they say, well, we'll go down to the station, I'll figure it out, and I'll when I book you. And then do we go by what he was booked for, or do we allow guesswork as to what was a reasonable person going to think at the time of the actual arrest?
We go by what he was booked for, which is more consistent and upholds the purposes behind speedy indictment and the concerns that were present in Wing. There's no, at the point that the defendant is told you are booked for X offense, there's no ambiguity. The defendant knows what he's arrested for. So the bright line test is easier to apply in those circumstances.
Well, in Wing, the defendant was never even brought down to the police station, was he?
No, he was not, Your Honor.
In fact, he was put into a squad car and then taken to his home and dropped off.
Correct, Your Honor, which might...
Why would he ever think that he was under arrest under your analysis then?
I think that for the totality of the circumstances, well, those are done on a case-by-case basis, and the state disagrees with Wing in its analysis of arrest. But in these circumstances, the court has consistently held transportation to the station for the implied consent procedures does not automatically transform an encounter into an arrest. And this differs from Wing in when we consider everything that happened throughout this entire interaction. Specifically, that the defendant was told it's cold outside by a friendly and in a conversational manner by the officer, we need to take you to the station for further testing. So it differs from Wing in those ways.
Was he handcuffed at the scene when he was taken to the station?
Yes, he was, Your Honor.
and put in the back or the front of the front seat?
I don't know if it's entirely clear, but I believe he was put, based off of the video and where he has walked back to, I believe he's in the back seat of the car.
You know, lawyers and judges in this line, to handle these cases would understand a detention for purposes of investigation, but wouldn't a reasonable person think when they're handcuffed and put in the back of the car and taken to the police station that they've been arrested at that point?
Not if we consider the statement that the officer made right before this interaction. The officer made it clear to the defendant that that he is simply being taken to the station to run further tests. So while those factors might be more indicative of arrest, when we look at all of the factors, this is not an arrest if we're applying the Wing totality of the
To avoid the need to relitigate this question, anytime somebody's picked up and there are potential multiple different charges, why not just have a bright line rule? We go by what you're charged with, in this case, public intox.
I think and that is the proper rule and how to deal with these circumstances in a way that can be consistently applied. The question for another day that does not need to be answered here is what happens when a defendant is not brought in and booked inside.
Let me ask you a question just briefly. If in Wing, the defendant was placed into the squad car, and we held that a reasonable person under these circumstances would feel like they had just been arrested, considering the roadside search and everything that preceded that. And yet, the transportation of that defendant not to the police station, but to his home where he dropped off and spent the rest of the night at his home, that did not eviscerate the arrest. We still found that he was arrested.
Correct.
Okay, in this case, he's taken to the hospital, given his Miranda rights, all of the implied consent procedures are gone through, a sample is taken for testing. Why would taking him then back to the station and telling him he's being booked for public intoxication, why would that eviscerate whatever happened at the hospital where it looked like he'd been arrested for OWI? How can in Wing the subsequent action not eviscerate it, but having him charged with public intox would in this case?
This is different. When offense specific is different from the arrest on arrest concerns that were present in Wing. And Wing relied on Davis, and Davis was overturned prior precedent with this arrest on arrest question because it was concerned about officers arresting someone when there was not probable cause and then using that as an opportunity to gain more evidence and then trying to say, no, we're not arresting you. And that was in a formal arrest situation, not in a Wing arrest due to what a reasonable person would believe. And the court and those concerns are not present here, and that there's still, especially when we're considering under the totality of the circumstances, this might be more akin to that if the officer did make a statement, we're arresting you for OWI, and then stated, no, actually I'm going to book you for public intoxication. That would be similar to the Davis case, which Wing had cited, so I don't believe those concerns are present here.
All right. Thank you. Counsel?
May it please the court,
Mr. Tiefenthaler.
it's quick. Your Honors, first I'd like to go a little bit over the facts of this, because I think the facts of this are important, especially with the discussion that we've had regarding the bright line issue. My client was in a parking lot late at night, early in the morning. The cops, he gets out of his car, he goes back to his car, basically to smoke a cigarette. The cops all of a sudden come to the parking lot sometime thereafter. Not one person had any conversation with my client after he had gotten out of his car and before he had returned to his car. Not any of the witnesses that had even seen him outside of his vehicle had any contact with him to suggest that he was under the influence of any alcohol whatsoever. All they saw
But-
was a man
but-
walking in the parking lot.
I'm sorry to interrupt you, but, when you have I think it was a 911 call, wasn't it? Or was it just a phone call? I can't remember. But in any event, the facts that are related, I don't think you need to have person-to-person contact with this individual if you see somebody stumbling from his vehicle to the restaurant and then stumbling back and then not having the ability to, get into his car. I mean, he ultimately did, but you place that much emphasis on the fact that I can't see somebody stumbling around a parking lot and can't make a valid assumption that he's intoxicated?
I think there are many reasons people can stumble, especially when it's cold out, especially in the wintertime. So I don't think that you can just jump from the fact that somebody stumbled to the fact that they might be intoxicated. The call that came in and the call that was routed out to the officer was for an intoxicated driver. It wasn't for an intoxicated person walking through the parking lot. It was for an intoxicated driver. But the officers come. They pull him out of his vehicle. The engine was running when they pulled up. So this is all my client knows at that point in time. They give him the HGN test. They give him a PBT test. At that point in time, they ask him, have you ever been arrested before? Now, at that point in time, they cuff him, stuff him into the back seat of the vehicle, take him down to the police station. On the way, somewhere in between, we're really not sure when it happened, he broke his toe. So they get him up in the police station. He's bleeding all over the place. The jail says, well, we're not taking him like that. So they say, take him to the hospital. They take him up to the hospital. That's when the officer invokes implied consent and reads him his Miranda warnings at that time. That's when he called me. I know you asked at that point in time, what was the conversation with his lawyer? Well, a lot of it resolved around the blood test, really, and whether he was going to consent to a blood test or not. I told him previously, he'll take the blood test. He won't take the blood test, but he'll take a urine test. And so all this time, you have about 2 hours that pass during the entire time he's up at the hospital. So I think you need to ask, how long can you wait before you tell somebody what they're being arrested for? I know Your Honor suggested a bright line rule of going what they're booked with. Well, how long are you going to wait to book somebody to tell them what they're being arrested for?
Well, in Wing, we came up with this reasonable person test because the officers did not comply with the code about how to arrest somebody. But didn't the officers in this case comply with all the code provisions dealing with OWI people? Number one, doing the preliminary breath test. The code authorizes them then to take them to the station to do a implied consent test, the breath test. And of course it was shortcutted because the code also allows him to make his phone call, which he did, where the attorney, which was you, got involved. They comply with all the code provisions. They took him down to the station and did their test, put on the form, you're not being arrested for OWI at this point. We're just here because your PBT was over and the code says you can do that if you're over. So I think if we apply Wing, do we even get to the reasonable person test like the Court of Appeals did if the court complied with all the statutory provisions up to the time of charging him? See, and that's the distinction I see. Because in Wing, we said, they were way outside the statutory provisions for charging somebody. I think it was 804 or something. And so when you don't follow the statutory proceedings, you have to use a reasonable person test. But here, all the statutory things were followed. So why does the reasonable person test even have any bearing on this case?
I believe the reasonable person test has a bearing on this case for this reason. Iowa Code Section 804.14 sets forth what an officer is supposed to do when he arrests an individual. That's the guideline that they need to follow. This officer conceded multiple times during his testimony at the hearing that he arrested my client at the scene. So I think it's disingenuous for the state to argue that he wasn't arrested at the scene when their own witness testified he was arrested at the scene.
I mean, isn't it fairly common that maybe not as much of a, maybe not the several hours that went on here, but there usually will be some time lag between the time the person is arrested and the time they're told what they're being arrested for officially. Isn't there usually some time lag?
I would say in a situation where they're not told at the scene. I think there's a time lag from the time they get him there till the time they get him down to the jail.
And then are you saying that what should always, instead of just going by what they're officially told that they're arrested for, we should then look at this interim period and what during this interim a reasonable person would have suspected? Isn't that kind of a test that's sort of fraught with uncertainty?
The problem I have with it in this case with this officer is I don't think he made his decision as to what he was going to do until after they had got back from the hospital. Your Honor had asked what he had said to me in the hospital. What he had said is, if he takes the urine test, I'm only going to charge him with public intox. If he doesn't take the urine test or he refuses it, I'm charging him with OWI.
There was a credibility issue on that, and I think the officer denied that, and the district court didn't credit that testimony. But putting even speaking from the perspective of your client, isn't it true that there were no urine test results that evening? I mean, they didn't come back till a month later, right?
They came back later, but within the 45 days. So if they wanted to file it within the 45 days, they could have.
Counsel, what was the drag time, the delay between the night of the incident and when he's ultimately charged with OWI?
I'm going to go off the best of my memory. It was almost like 3 months down the road because he was arrested. In fact, we didn't even know about it until we were told about it later. It was about 5 or 6 months later, I think, when he finally got arrested on the warrant and then officially proceeded at that point in time.
Well, I think the trial information's in August, and this is in January, so probably 7 months. Would that be right?
Yes, it was a long time, Your Honor.
Again, I got to go back. Why does 804 procedures preempt the more specific OWI procedures? And when you're doing an arrest or an investigation of OWI case, I mean that's bothersome to me because they're inconsistent with each other.
If there's nothing else to arrest for, then yes, I would say it'd be inconsistent. But for example, with 804.20, in that we kind of set a bright line rule about whether or not we're going to allow somebody to have a phone call or whether or not we're going to allow them to see somebody. If the officer violates that rule and does not allow them to do that, we're excluding that particular evidence. In this case, the officer didn't comply with 804.14, and I don't think they should get the benefit of the doubt in making that determination then if they don't comply with the specificity of 804.14 and tell them what they are being arrested for. I don't think you should be able to wait for, in this case, over 2.5 hours, if you're going to go with the booking rule, to say what he's being arrested for at that point in time.
Do these officers really know the difference between arrest, detain, and custody? I mean, we make these distinctions in the law. You don't have to be arrested to get your Miranda rights just to be in custody. I mean, we make all these fine distinctions, and when the officer says, I arrested him, couldn't he been using it synonymous with I'm detaining him? I mean, any time an officer says he takes someone in, of course he's going to say arrest instead of detain. I mean, what do you make of that?
Actually, I just had a hearing about a month ago involving this same issue where they said they were detaining my client. They actually searched him and did a Terry pat-down search on him. And then they didn't like some of the answers to the questions, so they said they were detaining him, and they handcuffed him, searched him, found something, and then they said, now you're under arrest. So I think officers do know the difference between a detention and an arrest. I think they use that distinction to some extent to their advantage because they don't want to have to give certain warnings, Miranda warnings, or anything of that nature if it's just a detention situation and not an arrest situation. So I think officers do know the difference. I think they use that difference actually to their advantage a lot of times in that particular situation.
Counsel, let me pause to ask you this question. When did, as Justice Mansfield was alluding to, when did it make more sense to have an event with some certainty to it that would trigger the time in which the state had to bring the indictment?
I think the event with certainty is already set forth in the code. 804.14 is the event. And yes, you can look at the totality of the circumstances in a particular situation like that. I have previously made the snapshot argument of it, but the snapshot argument that I'm talking about is the time when the person is taken into custody. Look at that snapshot of time. Look at the circumstances surrounding that period of time. Don't look at something that happens 2.5 hours later to determine what happened at that moment under 804.14 when you're taking that person into custody.
He can't arrest him for OWI until he sees if the gentleman consents to a blood test or a breath test. He can't arrest him for OWI until he knows what that breath test is.
Pardon me, Your Honor. Sure he can. The officer conceded in his testimony, did you have probable cause to arrest him at that time once he failed the HGN test? Yes, I could have, but I didn't. Could you have had probable cause to arrest him once he failed the PBT test?
But the crime of OWI is not, it's technically called operating while intoxicated, but it's really operating with more than .08. It's a strict liability thing once you get to .08. So why, it makes sense that an officer would not formally arrest somebody until they saw what that blood test or breath test was.
What if the defendant refuses the test?
Then he could arrest him immediately because it's presumed he's above the limit and apply consent. So he's stuck either way.
I don't think it's presumed that he's above the limit if he refuses the test. I think the refusal is admissible into evidence as to determine whether he's intoxicated, but officers make determinations regarding intoxication all the time. I mean, they use their field sobriety test, they use a distracted movements test, they use several other tests regardless of just the chemical test to determine whether or not a person is intoxicated. That's the same thing they try to do when they're trying to determine public intoxication. What they want to know is, are you operating the motor vehicle? If I've already made a determination that he's intoxicated, which if you're going to arrest him for public intoxication, you're kind of making that determination he's already intoxicated. So the next question is, was he behind the wheel of the vehicle? In this case, he was. I think that part of it, is why I think Wing does apply. I think that's why there is an arrest in this situation. I think the reason the state doesn't want to talk about it after that is because when you get to the reasonable person test in this situation, the only thing reasonable for my client to know was he was being arrested for drunk driving. He had no knowledge of what anybody else had said.
But why can't we accept Wing and use it for what it stands for? We can say that for purposes of the speedy indictment rule, everything starts at 2 a.m. or whatever when he's handcuffed and put in the back of the police car. But to determine what the charge is, that where the trial information has to be brought within 45 days, we then go by what he's actually booked for at 4:30 a.m. So we use Wing to determine the time of arrest, but we use the booking to determine what he's arrested for. What's wrong with that?
For the situation that some people are not always booked, and some people are released, some people are not always booked in a timely manner.
Right, well then, that's what happened in Wing, and then the state can accept the consequences where it doesn't timely charge the person, then that's a problem. But in this case, the person was charged within a matter of a couple of hours or 3 hours.
As a person, if I get taken into custody and somebody's arresting me for something and I feel like I'm under arrest, I have a right under the Iowa Code. I have a right to know what I'm being charged with. I don't think they should be able to basically tinkle around with the time and decide hours later what they actually want to charge me with.
But the officer has a right to take him in for the test once he flunks that PBT. So are you going to say in every situation where you flunk a PBT, you're arrested for OWI? I mean, that's what you're espousing right here. Because no person would know the difference unless they have like OWI 15th or something. But I'm telling you, a person who's brought in, so your test is if you flunk the PBT, you're arrested for OWI regardless of anything else. And that's the bright line rule you're doing.
What I'm saying is if they're going to be a situation where they're going to be put in handcuffs, put in the back of the car, I mean, if you want to have the guy say, hey, you want to come down and take some tests, have a seat next to me on the side of the car. And you guys voluntarily go down there together and you're not handcuffed, I agree, that's an absolutely different situation. That's a situation where I think you can take them in and do that if that's what you want to do.
You can't expect a policeman to transport someone in the front seat without handcuffs. That's a dangerous situation. I mean, let's get realistic about the way the world works. If you're going to transport somebody, you got to put them in the back and you've got to handcuff them. I mean, you can't do it any other way, especially if you think they're drunk.
I have seen officers actually take people in and say, will you come down and talk to us? Will you come down and take some tests for us? There are situations where it happens. Is it the smartest thing to do as a police officer? That's not something I would probably want to do as an officer, but it happens. But that's not what happened in this particular case and under these facts. I see my time is up. Thank you, Your Honors.
Thank you as well, counsel. Ms. Quick, rebuttal?
So, counsel, what's the limit? Is there any limit under your view of this legal principle to the amount of delay between the time they take the defendant in and they ultimately file the information?
I don't know if there could be a strict rule. I think it's something that needs to be analyzed on a case-by-case basis.
And what's your view of the record? How long was the delay in this case between the night of the incident and when he was ultimately charged with OWI?
I think that it's correct, and the night of the incident was in the middle of January, and he was charged in August. Trial information was filed on the OWI in August.
All right. So 8 months. So a year? Is there any problem with that?
Between
A
the
delay? Let's assume it was 12 months instead of 8. Would you be arguing the same argument you're making here today if it had been a year?
Yes, Your Honor, because we don't delay when we're thinking of speedy indictment comes into play in the good cause analysis.
Well, what's the purpose of the speedy indictment?
The purpose of the speedy indictment rule is to ensure a fair trial for both parties, for both the state, as the rule of criminal procedure states it is to ensure.
Well, it's a little more than that, isn't it? I mean,
Yes.
isn't the concept that there's only a limited period of time that we will expose people like this defendant to of uncertainty about whether they're going to be charged with an offense or not?
That's-
And so, I mean, as a practical matter, shouldn't we relieve that uncertainty in situations where there are potentially multiple charges, just as we would where there's only one?
There are competing concerns at play, Your Honor. Absolutely, one of the concerns is we want, this court has described, a defendant who's waiting for the other shoe to drop. But at the same time, we don't want to rush officers or the state into charging an offense until an investigation is completed, including, as was done in this case, the officer indicated, waiting until the strongest evidence is available. So that it's important when we're analyzing these issues to keep all of those considerations in mind. It's not just about, let's charge this as quickly as we can. You know, the defendant, there's multiple offenses that could be charged. We also need to take into account that the officers have the job they need to do as well.
Would you concede that if they didn't charge him with public intoxication and let him go that night without charging him, that Wing would say the 45 days ran from the date of arrest?
I would agree that that's what Wing said. I think in that.
Okay, now we got agreement. So why should the state be able to prevent the operation of Wing by charging him with this misdemeanor to prevent the running of Wing?
I don't think that that's what was the purpose or why this occurred.
I understand, but why, that's essentially what's happening here. If we adopt this rule to go with your charge with, why should the state be able to do that and just pick a charge to say I arrested him to avoid the consequences of Wing?
Well, this court has recognized the need to allow for that, as was in the Dennison case, and that the officers, as they did in this case, might not want to go forward with charges in those circumstances, especially in complied consent where there's a...
You got the test back within the 45 days. So tell me why, if this is the rule we're going to do in this case, I think every time the state does something like this, they could just say you're under arrest for spitting on the sidewalk or something, and the time will never run, and then a year later charge him with OWI. I mean, I don't know if that's fair. Tell me why it is.
Well, in those circumstances, again, I would just repeat the need that the problem could also be you're rushing officers. They might not want to charge for offense. They might charge for another offense because they want to investigate. And this could prevent officers from investigating someone who could eventually be cleared. So it's not automatically problematic that an officer wants to be cautious on charging for an offense. And I'd also point that the fact if there's a circumstance where there's been a long delay and there's concerns that it did harm the defendant, that a defendant is not left without a remedy, there's potential due process claims with a pre-indictment delay that could remedy any concerns in those circumstances.
Normally, how quickly do you get blood test results or urine test results back?
I believe the prosecutor stated, I personally do not know, I believe the prosecutor stated during argument that it can take several weeks.
Are there other situations, especially if you're testing for another form of narcotic, that it might take substantially longer?
I don't know. I know that sometimes it can take a significant amount of time, not only for the test to actually be done, but for those results to be sent to the prosecutor. For the reasons stated today and in the briefs, the state asks that this court reverse the decision of the Court of Appeals and affirm the conviction of the defendant. Thank you.
Thank you as well, Ms. Quick. State versus Penn Kennedy is submitted, and we'll now hear the arguments in LSCP.